Thank you for inviting me here today and for engaging me as a member of the jury. It was wonderful to be involved in this effort together with such distinguished colleagues. And for two reasons. First, I appreciate very much that this was a perfectly gender balanced committee. Although Alison and Maria Therese are not here, it's not your fault. You did the best you could. And I also appreciate that you invited me, I still consider myself young, I think. I don't know if I didn't know this getting older. But it's something that is important and I appreciate it. And I'm delighted to be involved in this effort because as Dirk and Thibault said earlier, I think it's particularly valuable for younger people to see that their efforts are rewarded even at such an early stage. So it's great that we're here. Now the job was assigned to me to present the Grand Prix, let's say, of this master thesis competition. And I have to say, although I'm presenting it, it was a unanimous decision who should get the big prize, so to say. So the big winner is Konstantinos Pantelidis. I'm extra proud because he's great, although I don't know him. But he really wrote an excellent, brilliant thesis. We thought that this is of such an excellent quality that it's ready to be published. And I think the prize goes to the deserved winner. So let me say a few words about Konstantinos' thesis. So Konstantinos Pantelidis' thesis tackles a debate that EU competition law has been circling for almost a decade. Whether the extraction of personal data by dominant platforms can amount to an exploitative abuse. In his master thesis, he cuts through the usual conceptual fog surrounding privacy and market power. The thesis maps how consent frictions and information asymmetries can create a form of non-price extraction that competition law has traditionally struggled to classify. By engaging with the German Facebook case and the broader post-Cambridge analytical enforcement landscape, he reconstructs the legal architecture of exploitative abuses and shows with welcome clarity where the doctrine stretches and where it breaks. More importantly, the thesis situates the privacy competition intersection in its proper analytical context. Konstantinos identifies the core trade-off. Competition law was built to police prices and quantities, not behavioral nudges or data appropriation. Yet, digital markets increasingly present harms that escape the traditional consumer welfare toolkit. His contribution is to articulate a structured framework for integrating privacy harms into Article 102 without importing the entire GDPR by the back door. It is a disciplined, forward-looking piece of work that shows how EU competition law might evolve while preserving its internal logic. For these reasons, Konstantinos is a fitting recipient of the Best Competition Law Thesis Award. So it was a delight, as I said, to read his thesis. Unfortunately, we will not be able to meet him in person today because he's currently pursuing his LLM at Harvard Law School, and in fact, he has an exam scheduled for this very day, which is unfortunate, but we are very happy for him, I have to say. So, nonetheless, he has recorded a video presenting his thesis, and I think Thibault is preparing to play now.
Hello everyone. It is a pleasure to be virtually among you all. Unfortunately, I could not be in there with you today in person, since at the time you're watching this, it's probably about 6 a.m. in Boston, and I'm waking up in preparation for an upcoming exam. First, I would like to thank the organizers of the competition at the International Center for Competition Law and Economics, as well as the examining committee for their positive evaluation of my thesis. Now, for the safety of the distance between us, I would like to say a few things about the project. This is my MPhil dissertation, which I will hopefully further develop into my doctoral thesis starting in the upcoming May. The research explores aspects of the intersection between competition law and privacy protection, a very hot topic that has gained loads of attention since I applied for it in the summer of 2023. Specifically, the research aims to develop frameworks for using competition law to protect consumers from excessive personal data harvesting. For the next few minutes, I will walk you through the project. The need for competition law. Issues associated with digital competition are one of the more well researched areas of competition law, particularly in recent years. Digital platforms live off personal data, which function simultaneously as algorithmic input, monetized asset, and de facto currency that consumers pay to access free services. Data is often collected via opaque terms and cookies, third party trackings, and data brokers. Alarmingly, through personal data, platforms can engage in exploitative practices like manipulation through nudging and dark patterns, behavioral targeting, and discriminatory practices. Meanwhile, consumers are structurally disempowered in digital markets, facing information asymmetries and cognitive limitations. Even when they are privacy sensitive, their stated preferences and behavior often diverge. As we know, there are two main restraints to consumer exploitation: market forces and regulation. Unfortunately, none of them are particularly successful in this case. Digital markets are generally concentrated, and self correction is limited due to barriers to entry and the inherent incentives of all platforms to overcollect data and manipulate consumers. Now, regulatory tools have been also inefficient. The GDPR suffers from fragmented and slow enforcement, and its reliance on self determination tends to leave consumers underprotected. New tools such as the DMA and the DSA are narrower in scope, largely untested, and for the most part refer back to the GDPR for privacy issues. Against all this, competition law is naturally positioned to scrutinize market conduct and directly adopts a consumer protection position. There are now a lot of arguments that competition law has to become part of the response. On the integration between the areas, the thesis does not seek to turn competition law into a general privacy regulatory tool. It treats competition as one tool among others, focused only on market specific conduct by dominant platforms. Conceptually, consumer welfare in the EU already goes beyond price to include quality and choice, so privacy and control over personal data can fit into this framework. To avoid regime blur, the thesis adopts an external benchmarking model. Competition authorities do not invent new privacy standards. They use existing rules, particularly the GDPR, as an external benchmark for fair treatment. A dominant firm's harm to privacy can often indicate exploitative conduct, provided there is linked to dominance. The thesis then develops external benchmarking into a standalone theory of abuse. EU practice has moved from skepticism about the competition privacy intersection in ASNEF Equifax to explicit recognition of privacy as a parameter of competition, mainly through the merger cases of the last decade. The turning point, however, is the Facebook decision of the Bundeskartellamt and the following CJEU judgment in Meta, which accepts that a dominant platform's GDPR infringement can matter under Article 102. Dominance undermines meaningful consent, and effective enforcement may require accounting for privacy. On this basis, I propose an external benchmarking abuse with three main elements. First, an infringement of a legal provision such as GDPR principles regarding data processing. Second, the provision needs to exist for the benefit of consumers for its infringement to harm consumer welfare. Third, there is need for normative causation. That is, dominance need not enable the conduct. It is sufficient that the conduct is especially harmful because of the dominance. For example, because the platform can over-harvest data and users cannot realistically avoid it by switching. Here, the thesis adapts the traditional law on excessive pricing. In many digital markets, consumers do not pay with money, they pay with their personal data. That data has economic value for firms, which suggests that we can speak of excessive data harvesting in close analogy to excessive prices. Interestingly, many of the objections to traditional excessive pricing do not apply in data harvesting. Since extraction cannot signal opportunity for potential entrants, competition authorities would not act as price regulators in the case of data, and markets cannot efficiently self correct. The proposed test adjusts the familiar two-pronged united branch structure. The first limb is excessiveness. The thesis adopts the cost-plus benchmark, whereby the authority asks how much data does the dominant platform reasonably need to cover the costs of providing and innovating its services and to earn a normal return. Data extraction beyond that benchmark is prima facie excessive. Use of comparators, for example, other markets or temporal comparisons, plays an ancillary role because digital markets tend to converge on over extraction. The second limb is unfairness. I consider the Katz approach infinitoin and the dual entitlement theory as alternatives. In the latter, the question is whether and to what extent the surplus dominant firms derive from data harvesting would arise under workable competition, given consumers' baseline entitlement to privacy and the set standard under a competitive market. Unfairness arises when the platform unilaterally pushes this balance in its favor without an adequate justification. Importantly, in both limbs, GDPR compliance functions as an external benchmark. Where processing infringes core GDPR duties, the harvesting should be treated as both excessive and unfair. To conclude, the thesis makes two main claims. First, competition law should take privacy seriously as an integral part of consumer welfare in data driven markets. Second, it shows how this can be done in practice by developing the external benchmarking and excessive data harvesting tests. I hope this gave you a good overview of the thesis. While I would enjoy taking criticism, questions, and feedback, this is unfortunately not possible in person, but it would be my pleasure to discuss with anyone interested over email. At this point, I would like to thank again the organizers and the examining committee, and I wish you all a lovely afternoon in the conference.